The High Court has turned 9 years of policy on its head by ruling that asylum seekers held in offshore detention can have their cases reviewed in Australia's courts. The decision opens the way for hundreds of appeals and longer stays in a detention system already bursting at the seams. The federal government says there are serious ramifications and it will announce its response in the coming weeks. Susan McDonald reports from Canberra.
It was from inside Sydney's Villawood Detention Centre that two Sri Lankan Tamils learned of their High Court victory.
I've spoken to them and they're really happy that they have the right of appeal in the High Court.
The men who came by boat more than a year ago were due to be deported. They pleaded injustice in the review of their refugee claims on Christmas Island. The High Court unanimously agreed the inquiries were not made according to law and were not procedurally fair. The court has, for the first time since 2001, given them rights to legal appeal in Australia's courts.
This is a landmark decision, not only for our clients and other asylum seekers, but the rule of law in this country.
Refugee lawyer David Mann says the outcome removes a key reason of coalition and Labor governments for offshore detention.
We also call on the government to abandon the offshore processing regime, which the High Court has unanimously ruled is fundamentally flawed.
The Greens won't wait for government action. They'll introduce a bill into Parliament next week, giving all asylum seekers equal access to the law.
So that all people, when they arrive, whether it's on Ashmore Reef or on the shores of Bondi or the Sydney International Airport, will all have access to the same rights of protection.
The government's taking legal advice and says it won't be rushed into responding.
Let's not get ahead of ourselves. We've got a High Court decision. The government will take legal advice on it.
It's the Immigration Minister's job to map out the path ahead. He's not ruling out new legislation.
This is a significant judgment. It has significant ramifications. It needs to be worked through in a methodical and calm manner, which is what I'll be doing in coming weeks.
Chris Bowen has been given some advice. He says the High Court's decision won't undermine the government's proposed asylum seeker centre in East Timor. And he's been told cases from the past can't resurface.
The advice to me is that this changes potentially the way we deal with things going forward, but the people who have already left Australia were dealt with under the law as it stood at that time.
But there are currently 145 detainees who will now get access to Australia's courts, and many more will follow.
It certainly does mean that the length of time for some people in detention, if they take up their appeal rights, would be lengthened.
People will have to remain in detention. The government, with already a detention crisis which is out of control, may well decide to just let people out.
The government is bracing for a system that's overcrowded to be even further stretched. And each appeal not only puts pressure on capacity, it comes with added costs to the taxpayer for legal aid and government lawyers. Susan McDonald, Lateline.